My name is Ibn Rasidin, and I'm going to present the question 1. In the first scenario, the issue that I have identified is whether oceanic lines is liable for the loss of cargo below deck caused by a fire originating from a container that was misdeclared as a metal part but actually contained a flammable solvent. Under the Hague-Visby rules, the carrier has a duty to exercise due diligence to make a ship seaworthy. However, there is an important exception. Under Article 4, Rule 2b, the carrier is not only liable for loss caused by a fire unless the fire was due to the carrier's own fault and negligence. On top of that, the Article 4, Rule 6 states that if the dangerous goods are shipped without the carrier's knowledge, the shipper will be fully responsible for any loss caused. This was clearly shown in the case of the Giannis and K, where the court decided that a shipper who misdeclared dangerous goods will be liable, even if the carrier has taken a reasonable care. So in this case, the shipper misdeclared the container and the oceanic lines only carry out the routine pre-shipment check with no reason to suspect that the cargo was dangerous. The fire started from the misdeclared container and there is no evidence that the oceanic lines was negligent. Therefore, the oceanic lines can rely on the fire exemptions under Article 4, Rule 2b, and the liability falls on the shipper under Article 4, Rule 6.
Hi, my name is Nurul Fatiha binti Pelimun. So today I will explain whether Oceanic Lines is liable for misdelivery and conversion of goods delivered without the original bill of lading. So under the Hague-Visby rules, specifically Article 3, Rule 2, a carrier has a duty to properly and carefully load, handle, carry, keep and deliver goods. When goods are shipped under a negotiable bill of lading, the carrier must only release the goods upon presentation of the original bill. If the goods are delivered without the bill, this amounts to misdelivery, which is treated as conversion under common law. This principle was clearly established in the case of Z Haitong Bank v Rambler Cycle. The court held that delivery without the bill of lading is a fundamental breach, and the carrier cannot rely on exclusion clauses to escape liability. In this case, Oceanic Lines delivered the weight to a neighboring mill without asking for the original bill of lading. Although the error was made by Porter at the terminal and was innocent, the carrier remains responsible for the acts of its servant and agent during delivery. Delegating delivery to port workers does not remove the carrier's legal responsibility. Furthermore, Oceanic Lines cannot rely on exclusion clauses because misdelivery without the bill is a serious breach of the contract. As a result, Tropicana Mills, as the lawful holder of the bill of lading, is entitled to treat the carrier's action as misdelivery and conversion. In conclusion, the Oceanic Lines is liable for misdelivery and conversion. The innocent mistake of the porter and any exclusion clauses do not protect the carrier, and Oceanic Lines must compensate Tropicana Mills for the loss.
My name is Tisharuna binti Muhammad. So the third issue is whether Oceanic Line breached its duty to exercise due diligence to make the vessel seaworthy by carrying dangerous cargo that caused a fire and loss of below deck cargo. So under the Article 3, Rule 1 of the Hague-Visby rule, a carrier must exercise due diligence before and at the beginning of the voyage to make the ship seaworthy, properly manned, equipped and fit to safely carry by the cargo. So the seaworthiness includes cargo worthiness, meaning proper storage, established in the case of McFadden and Blusa line in 1905. However, this duty is not absolute, meaning to say that the carrier only needs to act as a reasonable and prudent carrier. While under Article 4, Rule 6, if the dangerous goods are shipped without the carrier's knowledge or consent, the shipper is responsible for all resulting losses. The carrier is entitled to rely on the shipper's declarations unless there is reason to suspect danger, as the confirm of the case of Chinese NK 1988. Additionally, Article 4, Rule 2, Subsection B exempt the carrier from liability for the loss caused by fire unless the fire was caused by the actual fault or privity of the carrier. Hence, in this case, Oceanic Lines conducted regular pre-shipment checks and had no knowledge that the cargo was dangerous because it was misdeclared as metal part. There were no warning sign that would have alert a reasonable carrier to the hazardous nature of the cargo. So the fire was caused by the intrinsic danger of the misdeclared cargo, not by the poor stowage or the negligence or any defect in the vessel. Therefore, Oceanic Lines exercised due diligence and did not breach its duty of the seaworthiness. It means that Oceanic Lines did not violate its duty under the Article 3 of Rule 1. The loss resulted from the shipper's misdeclaration of dangerous goods and liability rests with the shipper, not the carrier.
So moving to the next question. The first issue that I have identified in the first scenario is whether the orchard export as a seller under a CIF contract is entitled to claim payment even though the ship sank during the voyage and the price was lost. Under the CIF contract, the seller main obligation is to ship the goods and tender compliance document, namely the claim of bill lading, invoice, and insurance policy. This type of contract is recognized as a sale of document rather than a sale of physical goods. This principle is supported under Section 32 of the Sales of Goods Act 1957, which allowed payment to be made against document. In the case of the Julia, the court held that once the seller tendered complete and compliant set of CIF document, the buyer must pay even if the goods are lost at sea. In this case, Orchard's export ship the rice CIF port plank and later tender a full set of clean bill of lading, an invoice, and an insurance policy, all in the form required by the contract. Although the ship had already sunk, the document proved that the goods were shipped. Therefore, the risk had already passed to the buyer. In conclusion, Orchard Export is entitled to payment, and Bear Mills' remedy lies in claiming under the insurance policy, not in refusing payment.
The second issue in this case is whether Global Foods can rely on its late nomination of a vessel on 15 June as substantial performance, and whether Orchid Export was legally required to accept that late nomination and load the goods. In commercial shipping contracts, especially FOB contracts, time obligations are treated very strictly. This is because international trade depends heavily on certainty and predictability. When a contract clearly states a date for vessel nomination, performance must occur on time. Late nomination does not amount to substantial performance, and the seller is not required to show flexibility unless the contract provides for it. These principles was clearly established in the case of Bank Corporation v. Tradex Export SA. In this case, the House of Lords held that time clauses in mercantile contracts are conditioned. A failure to comply with such a clause allowed the innocent party to terminate the contract immediately. The court rejected the argument that later performance could cure the breach. In the present case, the contract required Global Foods to nominate a vessel and give notice of readiness by 1 June for shipment in June. However, Global Foods only nominated a vessel on 15 June. This delay undermined the commercial certainty that Orchid Export was entitled to rely on. There is also no evidence that Orchid Export waived its right to timely nomination or accepted the late performance. In conclusion, Global Foods cannot rely on substantial performance. Orchid Export was entitled to reject the late nomination and terminate the contract. The seller did not breach the contract, and the loss falls on Global Foods for failing to comply with the strict time requirements of the FOB contract.
So the next issue is whether Baymil can refuse to pay under a CIF contract because the Orchid Export knew that the goods were lost at the sea where the shipping documents were tendered. So a CIF contract is a sale of documents, not a sale of the physical goods. Means that once the seller ship the goods and tenders documents that comply with the contract, so the buyer must pay. This is supported by under the Sale of Goods Act 1957, Section 32, which requires payment against conforming documents. Same as the case of the Julia 1949, where the court held that the buyer must pay against conforming documents even if the goods were lost before the tender. Similar with the case of Quay Tech Chow and British Traders and Shippers 1854 confirmed that the loss of goods doesn't amount to a failure of consideration in a CIF contract if the documents are genuine. An exception applies only where there is fraud or false documents, as explained in the case of Dairy and Pig 1889, but the knowledge of loss alone doesn't amount to fraud. Here we can see that Orchid Export shipped the rice before the vessel sank and later presented clean bills of lading, an invoice, and an insurance policy, all in accordance with the CIF contract. Although Orchid Export knew the loss at the time of the tender, the documents were honest and accurately reflected to the shipment. That means that there were no fraud or false. Baymil also had the right to recover the loss under the insurance of policy. Here, we can say that Baymil is legally obligated to pay Orchid Export upon tender of the confirming documents. The seller's knowledge of the loss doesn't excuse non-payment, and Baymil's remedy lies in claiming under the insurance policy, not refusing to pay.